All right, folks, let's bring this meeting to order. I'm Judd Campbell. I'm a faculty member here. I'm standing in for Michael McConnell, who's off traveling this fall. We got a busy lineup of events, and really glad that you could make it out to this one. For a talk by Matthew Seligman. Matt was one of my classmates here at SLS. He also has a PhD from NYU in philosophy. He's developed a really interesting career at the intersection of academia and litigation and public advocacy. And so he's going to bring some insights here today from his work, both as an expert on constitutional law. He's also developed quite an expertise on election law, as well as his role litigating, including his efforts in front of Judge Cannon with respect to the constitutionality of the special and legality of the special counsel appointment. And I'll also just mention that Matt has written a ton, including a recent book with Larry Lessig, and has done quite a lot of work relating to electoral count reform measures and other things relating to threats to the election system. So a really interesting guy. Looking forward to the talk. Thanks so much for joining us, Matt. And as usual, we'll take questions after, so be thinking of questions as the talk proceeds. Thanks so much.
Thank you to Judd. It is so wonderful to be back here at Stanford Law School. So Judd and I we're very good friends. We remain good friends. And so it's really wonderful to interact with people that you went to law school with years later to see all of the incredible, impressive things they do. So for those of you who are law students, make sure that you look to the person next to you, and then one day they'll be really fancy and famous like Judd is. So I'm here to talk about my role arguing in front of Judge Aileen Cannon about the constitutionality of the special counsel. So I'll give a background on the long history that led to this moment, what the legal issues are, and where we go from here. So the special counsel is a particular type of official within the Department of Justice. And there's a long history going back, depending on how you count, decades or even centuries. The basic idea here is that there are certain types of cases where the political sensitivities involved mean that as a policy matter, people think that there's an important sense of independence that prosecutor should have. And so one of the original special prosecutors, as it was called back then, was the Watergate special prosecutor. And so the idea there was that the president himself was under investigation and then potentially subject to prosecution. And it didn't really make sense for the attorney general that he had appointed to then investigate him. And as a result of that, there was a special prosecutor that was appointed. And the idea is that special prosecutor would exercise some kind of independence in making investigatory or prosecutorial decisions. Now, that didn't turn out so well for President Nixon. Now, back then, it was just sort of a policy decision. The attorney general could appoint the lawyer and say, okay, you're going to be the special prosecutor for Watergate, and I promise that I'm not going to interfere. I'm not going to intervene. Now, after Watergate, there was this federal statute that was passed called the Ethics in Government Act. And this codified what had previously been just a matter of policy. And so it authorized the appointment of an independent counsel. The independent counsel could be appointed in sort of a variety of different complicated ways and could not be fired but for cause by the attorney general or the president. And that codified that independence, that even if the independent counsel went off and did something that the president or the attorney general didn't like, they couldn't be fired. And so there were a number of independent counsels that were appointed pursuant to the Ethics in Government Act, culminating in Ken Starr. Ken Starr was the Whitewater independent counsel who investigated President Clinton and his wife, First Lady Hillary Clinton, for a wide range of different problems, potential ethical problems, potential criminal issues, and that led to President Clinton's impeachment. And so after that impeachment happened and ultimately failed, there was no conviction in the Senate, there was a recognition across both parties that this had gone too far, that Ken Starr had such a degree of independence that he couldn't be fired essentially for any reason at all. So being fireable only for cause means that you have to commit a fireable offense. So something like malfeasance in office, some kind of corruption, et cetera. But just taking prosecutorial decisions that the Attorney General or the President doesn't like doesn't cut it. That was supposed to be the virtue of the independent counsel. The problem is that, well, if you have an independent counsel who is not accountable really to anybody, then this becomes a roving mandate to look for scandal. And so by 1999, there was a recognition among both parties that this had gone too far. So the Ethics in Government Act lapsed in 1999, and it was replaced by a set of regulations. So everybody recognized that the statute went too far, and so instead it was replaced with a set of regulations that the Attorney General adopted. So these regulations provide for the appointment of a special counsel. And these regulations set up a process of appointment. It says a little bit about how the special counsel is supposed to work. It sets up some reporting requirements, saying that the special counsel has to provide a report, updates about the investigation and prosecution to the Attorney General, both at regular intervals, and if there's any major investigatory or prosecutorial steps. And it includes a provision that says in these regulations that the Attorney General will terminate the special counsel only for certain types of reasons. Now, this can sound a lot like the Ethics in Government Act, but there's a really critical difference here. And the critical difference is that the Ethics in Government Act was a statute, and that meant that Congress passed it, the President signed it, and that means that the Attorney General can't ignore it. Now, by contrast, the special counsel regulations are just regulations that were adopted by the Attorney General, and the Attorney General can rescind them at any time. And as we'll talk about with the specific case of Special Counsel Jack Smith, it's even easier to get rid of him than that. So that's where we were at the turn of the century. And since then, there have been about a half dozen special counsels that were appointed to investigate a wide range of different types of problems. So one was during the Bush administration when Valerie Plame, who was a CIA operative, her identity was disclosed to the New York Times. So that was investigated. And the idea there was that the people who were suspected of leaking that classified information were probably political associates of the president. And so that's the kind of case where it kind of makes sense, where you don't want the president and the Attorney General, who is appointed by the president and a political ally of the president, to have direct control over that investigation. Now, starting in 2016, there has been a marked uptick in the number of special counsels. And so there are different theories about why this is the case. But there's no question that, that the peculiar presidency of Donald Trump is one of the factors. Now, he's not been the only target of special counsel investigations, but he's been one of them. In addition, Hunter Biden has been now prosecuted by a special counsel. The reason why that makes sense is because Hunter Biden is President Biden's son. And so having the Attorney General, who again is appointed by the president and a close political ally of the president, be in charge of the prosecution of the president's son, well, it looks like there's a conflict of interest. So it makes sense to say, okay, we're gonna have a little bit of independence there. And so now we get to Jack Smith. So Jack Smith was appointed as a special counsel by Attorney General Merrick Garland. And he was appointed, so he has a letter of appointment that says that the special counsel regulations apply to this appointment. And Jack Smith's mandate is limited. It's limited to 2 incidents. The first is the events arising from January 6th, not including any of the violence, people who are physically present on the Capitol grounds. And so it's specifically targeted at President Trump and any of his other associates who might be co-defendants in that case. That gave rise to an indictment, which has also been legally eventful, which that ultimately led to the Supreme Court's immunity ruling on July 1st this past year. And we can talk about that too if you have any questions. Now, the appointment letter also covers the Mar-a-Lago classified documents case, which is why we're here. So the Mar-a-Lago classified documents case, for those of you who may not remember, because there's so many legal cases going on involving the former president. So the classified documents case arose because former President Trump, when he left office, took some classified documents with him. Now, this, unfortunately, is something that kind of happens a lot. So presidents, vice presidents, et cetera, sometimes accidentally take classified documents with them. So as somebody who clerked and had security clearance to work on Guantanamo Bay cases, it is unthinkable to me that you could accidentally take home classified documents, but it actually does happen fairly regularly. President Biden was investigated for this. Mike Pence was investigated for this. And on and on and on. Now, the difference between Trump's case and the others is that Trump committed a crime, or at least so it's alleged, because he willfully retained national security information. So the idea is that he knew that it was there, and he refused to return it anyway. And that's what elevates it into a crime. Now, Merrick Garland, the Attorney General, appointed Jack Smith to prosecute these cases precisely because former President Trump is President Biden's political opponent. Now, the appointment took place prior to former President Trump announcing that he was going to run for president again, but it was fairly obvious that there was a political conflict of interest there. And so Merrick Garland decided to appoint Jack Smith as a special counsel to investigate those two incidents, and those two incidents alone. Okay, so now how do we get to the question of whether the special counsel is constitutional or not? So here we'll do a little bit of actual law. So this is the Appointments Clause of the Constitution. And so this is the clause in Article 2, which establishes the presidency, which sets up the basic legal framework for the president's power to appoint officers. Okay, so officers is an important term of art here. So the clause here says that the president shall nominate and bind with the advice and consent of the Senate. He shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States. But, going down to the last sentence, the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, meaning no Senate confirmation required, in the courts of law, or in the heads of departments, like the Attorney General. So there are two legal issues that arise with respect to the lawfulness of the special counsel. The first legal issue is a constitutional question about whether the special counsel is a superior or inferior officer. And the reason why that makes a difference is because, as we can see here, an inferior officer is an officer where Congress can pass a statute and vest that appointment power in the president alone, or, as relevant here, a head of department, the Attorney General. But if the special counsel is a principal officer, then Congress can't do that, and that appointment has to be made by the president with Senate confirmation. And so the first threshold question here is whether the special counsel is a principal or inferior officer. That's question number one. Question number two is if the special counsel is an inferior officer, that doesn't automatically mean that the Attorney General can make that appointment. That just means that Congress can, if it wants to, pass a statute that says that the Attorney General can appoint the special counsel. And so the question then is, has Congress actually done that? Has Congress passed a statute that vests the appointment of the special counsel as inferior officer in the Attorney General? That's question number two. So the question of the lawfulness of the special counsel comes down to these two questions. The first, the constitutional question about the status of the special counsel as principal or inferior officer. And the second question is whether, if an inferior officer, Congress has vested that appointment via statute in the Attorney General. Okay, so those are the two questions. Now, we have the Constitution here. We also will have some statutes that I put up here, but we also have cases. And it turns out that both of these questions have been answered definitively by the Supreme Court, saying that the special counsel is an inferior officer and that Congress has vested that appointment in the Attorney General. So you might wonder, why are we here? And many other people ask the same question. So the first, so the case Nixon. So President Nixon had this special prosecutor and challenged the special prosecutor's subpoena of his tapes. And so these were the famous Watergate tapes. And so this went all the way to the Supreme Court very quickly. It turns out the Supreme Court can act very quickly when it wants to. And so it went to the Supreme Court, and the Supreme Court ruled unanimously that the special prosecutor is an inferior officer and that Congress had passed a bunch of statutes that vested the special prosecutor's appointment in the Attorney General. Now, this came up again in a case called Morrison v. Olson. So Morrison v. Olson was a challenge to the independent counsel under the Ethics in Government Act. And so this was during the Reagan administration. And the Supreme Court said that the independent counsel, which was just like the special prosecutor and just like the special counsel, except had these statutory protections, so it was even more independent, was an inferior officer. And so again, the Supreme Court held unanimously that the special counsel, or independent counsel in that case, was an inferior officer. And indeed, Judge Cannon held that she was bound by these precedents, at least with respect to the constitutional question. She said that she had grave concerns about whether the special counsel is in fact an inferior officer. But nonetheless, she recognized that she was bound by precedent. She did not, however, recognize that she was bound by precedent on the statutory question, on the question of whether Congress had actually passed a statute that vested the appointment power of the special counsel in the Attorney General. So let's step back for a second and talk about why I was there. And I just want to say it was extremely uncommon, exceptionally uncommon, to the point of being bizarre. So I, in addition to being a fellow at the Constitutional Law Center here at Stanford Law School, I'm also a practicing attorney, and I write some amicus briefs sometimes. And so I had seen that Judge Cannon entered an order on her docket back in February, accepting for filing an amicus brief that was filed by, among others, former Attorney General Ed Meese, and some legal academics. And the docket entry said that she found that the brief would be of great help in resolving the questions before the court. Now, the reason why there was even a docket entry here is because there usually aren't amicus briefs in district court cases, in the trial courts. There's no rule that lets you do it. In the courts of appeal, you can file them. In the Supreme Court, they get stacks and stacks of amicus briefs. But in trial courts, it's really, really uncommon. And I saw that there was this docket entry, and I started getting worried. And I was concerned, so Judge Cannon has been criticized in some quarters for her decisions in the classified documents case. Even before the indictment happened, she tried to somehow enjoin the FBI from reviewing documents that it had seized at Mar-a-Lago pursuant to a valid search warrant. And so I was a little bit concerned that she might be up to something. And I was particularly concerned because if the special counsel's appointment is unlawful for Mar-a-Lago, it's also unlawful for the January 6th case. And that's how I initially had become involved in any of this, because I do some work on disputed presidential elections. So I got worried. So I made a couple of phone calls and organized a group of primarily conservative amici. So primarily these were people who had served in high-ranking Department of Justice positions in the various Bush administrations, the Reagan administration, one special counsel who had served under Bush, Patrick Fitzgerald, was also an amicus, also Larry Tribe, who's a distinguished, decidedly not conservative law professor. And so there was this nice group of people. I wrote this brief, and I thought that was going to be the end of it. And I had a couple of specific doctrinal reasons why I wanted to file as well, which I'll get to in a minute. And then something very weird happened. Judge Cannon, so there were three amicus briefs that were filed, the one that I wrote, the Ed Meese brief, and then this other one, the brief was written by Josh Blackman, who's a law professor in Texas, and he represented another law professor named Seth Barrett-Tillman, who teaches American constitutional law in Ireland. And he's a little bit of, I would say, an independent thinker. So he was responsible for the argument that the Supreme Court considered in the in the disqualification case under the 14th Amendment, there was this argument that the president is not an officer and therefore is not disqualified by Section 3 of the 14th Amendment. So that was that guy. And so there were these 3 amicus briefs. Okay, you file an amicus brief and then the parties argue the case and that's that. So Judge Cannon issued this order saying that if any of the amici wanted to participate in an oral argument, we should file a motion and ask. And so to me, that telegraphed pretty clearly that she would say yes, at least to the 2 other amicus briefs, both of which were supporting the former president. So we waited and waited and waited to see if the other amici would file such a motion, and then they did. And I was kind of on the fence because this is really extraordinary thing for the judge to do. It's just highly procedurally irregular for amici to participate in oral arguments. So much so that when I ultimately filed the motion to participate after consulting with my clients, the amici, I felt like I needed to sort of confront the elephant in the room, which is that this is extremely weird. And so I couldn't find any data whatsoever about amici participating in oral argument at the trial court level. And I think it's because it has never happened. I know there's an important caveat for non-governmental amici. So the United States government will often participate in cases as an amicus between 2 private parties or a state government. And so there was data about the Supreme Court. And so in this motion, I explained that we recognize that this is extremely uncommon. Indeed, at the Supreme Court, where amicus briefs are ubiquitous, there are sometimes dozens in a given case, a non-governmental amicus has been permitted to participate in oral argument 9 times in the last 4,000 Supreme Court cases. So it's just extraordinarily rare, even at the Supreme Court. So I wanted to sort of make that concession to reality while making this request that if the other side got to participate, we felt that it was important that we participate too to put things on an equitable basis. And so she granted the motion, and so I headed down to Fort Pierce, Florida on June 21st to participate in the oral argument. So I thought when this argument was going on that the government was going to win. So Judge Cannon has been criticized quite a bit for her various decisions and actions and just way of conducting the case. Now, an important bit of background, I think, about Judge Cannon is that she's primarily an appellate lawyer before being appointed to the bench. She did maybe 2 or 3 trials as an assistant U.S. attorney, but the vast majority of the work that she had done, she's still young, she's only been a lawyer for about 10 years, but she had been an appellate litigator. And I understand that. I'm an appellate litigator as well, and so if you put me in charge of holding an evidentiary hearing, I would have no idea what to do. Now, to my mind, that's a pretty good reason why I shouldn't be a federal trial judge. But nonetheless, I can sort of understand how she's still getting her sea legs for sort of the nuts and bolts of trial litigation. Now here, this is a pure appellate issue. This is a quintessential issue that at this point it seems likely will go back to the Supreme Court. And so this is something that I'm much more comfortable with, and it seemed like Judge Cannon was much more comfortable with it as well. She was very well prepared. She knew all of the cases, she understood everything, and in the course of the argument, she asked good questions, and with one exception that I'll get to in a second. And she actually she pushed Trump's lawyer quite hard. And so I thought, with one exception that I'll get to in a second, I thought the government was going to win after the 5 hours of oral argument. Now, that is a lot of oral argument. So Supreme Court oral arguments are 1 hour total. Most trial court arguments are, 5-10 minutes. Court of Appeals arguments are usually about 10 minutes. So this was a lot of oral arguments. So I thought that the government was going to win, with one exception. The exception was that at the very end of the argument, she pressed James Pierce, the attorney who argued the case for the special counsel, about how much Attorney General Garland was actually, as a matter of fact, involved in the day-to-day operations of the special counsel. How much was he actually overseeing the special counsel? Now, this is both legally irrelevant and also very dangerous for the special counsel. The reason why it's legally irrelevant is because, so this question about whether there was actually oversight on a day-to-day basis ultimately goes to, was the decision to prosecute, to indict the former president, was that decision made independently by the special counsel, or was that decision made by the attorney general? So this goes to a legal issue and it goes to a political issue. The legal issue is the special counsel an inferior or a principal officer? Now, the doctrinal definition of a principal officer is an officer who has no superior, whereas an inferior officer is one who does have a superior. And so what Judge Cannon was asking about there is, okay, does Special Counsel Smith actually have a boss or not? And now the answer here as a legal matter is yes. And the reason is because that letter appointing Special Counsel Jack Smith says that these regulations apply, but there's no statute. There's nothing that prevents the Attorney General from rescinding the special counsel regulations whenever he wants to. And indeed, it's easier than that, as I alluded to at the very beginning. He doesn't even have to rescind the special counsel regulations. He can just write another letter that says, I've decided the special counsel regulations no longer apply to you, Mr. Smith, and you're fired. Bye-bye. And so that's all it takes. The restraints on the Attorney General's oversight and control of the special counsel are purely self-imposed. It's like a New Year's resolution. It's good while it lasts, but not binding if broken. And so, as a constitutional matter, it's pretty darn clear that the special counsel is an inferior officer. The reason why this was an exceptionally dangerous moment for the special counsel is because, of course, what Judge Cannon was trying to do is get the special counsel to admit, one way or another, either this is a rogue prosecutor who's not accountable to anyone, who's on a political vendetta against the former president, or that this prosecution was directed by the Attorney General. And so either answer would have been, let's say, politically very dangerous for the special counsel's office, for the Attorney General, for the Biden administration. Now, he resisted answering the question, ultimately didn't. He did a little bit of dancing, saying, I don't know if I'm authorized to answer any of those questions, et cetera. Referred back to the regulations in the appointment letter. Ultimately, that question was unresolved. So the way that I thought this was going to go is that she would uphold the constitutionality of the special counsel and the lawfulness of the special counsel's appointment, but then try to get more fact-finding. Try to force the special counsel to say whether the Attorney General had directed the indictment of the former president. Turns out that didn't happen. The reason it didn't happen is contrary to my expectations. Judge Cannon decided just a couple of weeks later in a 100-something page long opinion that was released on the morning of the first day of the Republican National Convention, which some people thought was not a coincidence, saying that the special counsel was unlawful. So she, again, agreed that the special counsel's status under the Appointments Clause is one as an inferior officer. She said she had great doubts about that, but she was bound by precedent. She decided she wasn't bound by any precedent. To be fair, that she said there was no binding precedent on whether Congress had actually passed a statute to authorize the Attorney General to appoint the special counsel. Now, other courts, so for most importantly the DC Circuit, which has confronted this question numerous times for over 30 years, has held that there is a statute. In fact, multiple statutes. She's not bound by that because she's in the Southern District of Florida, which is in the 11th Circuit. So she said, yes, I recognize those other courts have made that decision, but there's no Supreme Court precedent on point. Now there is, but she said there wasn't. And so she said that there was no statute on point. So let's get to the statutes in our last couple of minutes here before I open this up for questions. So I mentioned that there was a doctrinal reason why I thought it was important to file this amicus brief. And the reason is because I think the Department of Justice argues this issue wrong. So the Department of Justice and the courts have relied on two separate statutes as giving authority to the Attorney General to appoint the special counsel. So here is the first one, 23 U.S.C. section 515A, and then I will flip over to B. So this is the part of the statute that the Department of Justice says authorizes the Attorney General to appoint the special counsel. Now, there's no dispute that the Attorney General can hire what are called mere employees. By the way, that guy, Seth Barrett-Tillman, the Irish-American constitutional scholar, said that the special counsel was not even an inferior officer. So Trump had argued that it was a principal officer. Tillman argued that he wasn't even an inferior officer. He was a mere employee because he was too intermittent. He didn't have a permanent appointment, and that made him kind of like an Uber driver. So nobody really took that argument seriously. But there's no dispute that the Attorney General can hire employees. But what you'll see here is there's nothing in here that says that the Attorney General can appoint anyone. It just says each attorney specially retained, past tense, under authority of the Department of Justice, shall be commissioned as a special assistant, et cetera, and take an oath. And then going back to A here, it says that the Attorney General can direct any attorney within the Department of Justice to prosecute any case, take on any matter. Now, what this sounds like is it's statutory authority for the Attorney General to do stuff with attorneys who are already within the Department of Justice. Jack Smith was not already within the Department of Justice. He was a private citizen. He's actually a prosecutor overseas for an international court at the time, not employed by the Department of Justice. Now, so the text of these two statutes are a bit of an uneasy fit. Now, the history actually supports the Department of Justice. So this statute goes back to 1871 when the Department of Justice was first created. And there was sort of this question about attorneys who were, sort of hired for short periods of time. Did they have to take an oath, et cetera? But there's no statute going back then that actually authorized the Attorney General to appoint anybody. It was just assumed that it was included within this authority here. But we live in a highly textualist age. And so I was concerned that that wouldn't be enough to carry the day. And so I thought it was very important to file a brief that relied on a different statute, 23 U.S.C. Section 533. Now, the relevant subportion here is 1. And so this says the Attorney General may appoint officials to detect and prosecute crimes against the United States. This, to me, seems pretty textually clear. And I thought I had convinced Judge Cannon that that gives express statutory authority for the Attorney General to appoint an official to detect and prosecute crimes against the United States. So what did she decide on this? Well, what she said is 2 things. 1, that the word officials does not include officers. That was point number 1. And point number 2 is that this provision is found in a subchapter of the United States Code, the heading of which is the Federal Bureau of Investigation, which is a subpart of the Department of Justice. And so she said, Jack Smith is not part of the FBI, so this doesn't authorize him to be appointed at all. Now, that's wrong, and we can talk about why it's wrong. But ultimately, the decision that Judge Cannon made is that that sentence, the Attorney General may appoint officials to detect and prosecute crimes against the United States, does not provide the statutory authority here to Congress to appoint any inferior officers. Now, the any here is really important. The special counsel is not the only inferior officer in the Department of Justice. To name a few, there are 11 deputy assistant attorney generals who are within each of the component divisions. So, for example, the criminal division, the civil division, the environmental division, the Office of Legal Counsel, and so on. All of them are inferior officers. None of their appointments would be lawful if Judge Cannon is right here. Even more than that, the principal deputy solicitor general of the United States is an inferior officer. The principal deputy solicitor general of the United States argues before the Supreme Court on behalf of the United States, usually about a half dozen cases a year, and very often serves as the acting solicitor general of the United States because there's not a Senate-confirmed solicitor general, roughly a quarter of the time. And that means that according to Judge Cannon, the person who argues on behalf of the United States before the Supreme Court has been unlawfully appointed for decades, and not a single Supreme Court justice noticed it. So that seems like a pretty remarkable fact to me. Now, this case is now on appeal in the 11th Circuit. Last month, I filed a brief there as well that reiterated the arguments about the statutory authority here, and also suggested that potentially Judge Cannon should be removed from the case. Now, that is an extraordinary suggestion, and it was one that I was really uncertain about whether we should make it. Now, there's a standard for this. Sort of courts of appeals have sort of plenary supervisory authority to reassign cases. And when they do so, it's usually in response to conduct by the district judge that manifests the appearance of bias. And I think that there's a fair inference here that Judge Cannon, not just in this decision, but in the other decisions that she's made, for example, before the indictment, where the 11th Circuit had to put a halt to her. She assigned a special master to review the documents that had been seized so the FBI couldn't see them. And the 11th Circuit, which, by the way, is a very conservative court of appeals, reversed her and said that her decision flouted bedrock principles of the separation of powers. And then this decision here, which I've gone through the merits of the statutory analysis, but there's binding Supreme Court precedent on point here. The Nixon court said, well, the Attorney General has appointed the special prosecutor pursuant to statute, and then listed a whole bunch of statutes, including both Section 515 and Section 533. So it looks like she's knowingly flouting binding Supreme Court precedent and ignoring what looks to me to be pretty clear text in a political context in which some have suggested that she has an incentive to protect the former president from prosecution. Now, I'm not here as a practicing attorney who currently has a brief in the 11th Circuit about this, going to suggest that she's consciously biased. What I am going to suggest is that a reasonable person could think so. And that is enough to undermine the appearance of impartiality that is really critical for the rule of law to continue to persist. And we already live in an environment, especially because of these prosecutions, where people think, one side thinks that they're politicized prosecutions, the other side thinks that the judges who are blocking the politicized prosecutions. So there's a real crisis of the perceived legitimacy of the federal courts here. And you could hear this in the immunity decision, for example. Whatever you may think about the merits of that decision, I think it's clear that Chief Justice Roberts, in writing it, was very concerned about the federal judiciary getting involved in these types of political cases. Now, the upshot of that crisis of perceived legitimacy is, well, different things to different people. Some people think that these prosecutions of politicians should stop. Or I should say, some people think that these prosecutions of a politician should stop. Some people think that this means that the courts are sort of falling down on their duty to apply the law without fear or favor, no matter who the defendant is. Now, I'll close with one last thing before we get to questions. So it's been widely reported that this means that the case is dead, and it's not. Just like it's been widely reported that the January 6th case is dead, it's not, with one possible caveat there, which is that if the former president wins re-election, he will order the Department of Justice to drop the charges, and this is where the lack of statutory protection for the special counsel actually would make a difference. He can, first day in office, could and almost certainly would fire Jack Smith and order the Department of Justice to drop the case against him. The case is against him. But aside from that, even if Judge Cannon is right, the case just gets transferred to the U.S. Attorney for the Southern District of Florida, and the case goes forward. This is delay. That's it. And similarly, in the January 6th case, the vast majority of the conduct that's alleged in the indictment in the January 6th case is unofficial conduct. It's not part of the job of the president to do the vast majority of the stuff that's alleged in that indictment. So one way or another, these cases will go forward unless the Department of Justice is ordered to drop them. So as we are now 35 days away from Election Day, that's a bit of context of some of the legal stakes of the decision that the American people are about to make. And with that, I'd love to hear your questions.
You guys can queue either here or over there. I'll turn that mic on next. Come on down.
Thank you. What do you say, I don't know if this is on or not. I'll speak up. Judge Cannon said that the Nixon case was only dicta. It wasn't really argued. What's your response to that?
So for those who didn't hear the question, Judge Cannon in her decision said that the Nixon case, where it said that Congress had appointed the special prosecutor in that case and then cited a bunch of statutes. So how can she get out of following that? You know, we live in a hierarchical system of courts where, you know, lower courts are supposed to follow the decisions of the Supreme Court. And so what she said is it was dicta. Now, the basis of her argument here is that she said that it was not necessary to the decision in that case. It was just something that was said offhand. Now, I don't think that's correct. And the reason why I don't think that's correct is because, so the issue in the case there was you had the special prosecutor who had secured a subpoena for the Watergate tapes. Then you had the president. And so this set up an extraordinary question about the separation of powers and executive power. And prior to that question being resolved, the Supreme Court had to determine whether the special counsel was even authorized to get the subpoena in the first place. Without that, then there would be no justiciable controversy, which is a jurisdictional question. So the Supreme Court had to address it. And it said, yes, there was a justiciable controversy, and the reason is because the search warrant was validly sought by a prosecutor. How do we know that that prosecutor had the authority to do it? Because the prosecutor was appointed by the Attorney General pursuant to statutes that Congress had enacted. So if the special prosecutor in Watergate didn't have, wasn't lawfully appointed pursuant to the statute, then there was no real controversy there because you had somebody who was basically an interloper who had no lawful authority to get a search warrant in the first place. And because of the extraordinary nature of this intra-branch dispute, which was the primary question that the Supreme Court addressed is, well, what's going on with this intra-branch dispute between a Department of Justice attorney and the president? Can we even resolve that kind of question? And the Supreme Court said yes, 9-0. In order for that question even to arise, it had to be the case that the special prosecutor was lawfully appointed by the Attorney General pursuant to the statute. Yes?
Kind of similar in terms of like separation of powers. I was trying to go through the Ethics in Government Act with one of my professors at Santa Clara, and we kept going, debating over what the best solution is by statute for the special counsel. It seemed like Ethics in Government Act had the judicial branch appoint someone, which crossed over separation of powers, and I was wondering, how do you kind of resolve this, given that lesson?
So the Constitutional Law Center here had a conference here in May, and the keynote speaker was Jack Goldsmith. So Jack Goldsmith is a professor at Harvard. He's one of my mentors. When I first got in the academy, he was also the Assistant Attorney General in charge of the Office of Legal Counsel during the Bush administration. He was quite famous for rescinding the torture memos and then resigning. So he's a really principled guy. He's not a Trump supporter. He wrote a book with Bob Bauer called After Trump, which is trying to somehow repair the executive branch in the aftermath of Trump's damage against it. And so Jack Goldsmith's keynote address at this conference in May here was basically that this was a failed experiment. The special counsel, the independent counsel, the special counsel, just a big failed experiment. His view is that, as a policy matter, the right balance to strike here is just to have the Attorney General appoint a prosecutor who can be fired at any time. Just say, okay, you, prosecutor, or even just an ordinary prosecutor in the Southern District of Florida, you go prosecute this case without any kind of protections at all. Now, the reason why Jack thinks that's the right solution is because he thinks that this obscures the lines of political accountability. It's some kind of like in-between thing. And Judge Cannon's questions actually sort of highlight that fact. Because on the one hand, the Attorney General does retain the authority to terminate the special counsel, but everybody talks about how he won't do that, and he refrains from exercising that authority. So what we have here is from the Ethics in Government Act, which actually was a very creative appointment system. You can see here in that last sentence, the Congress may by law vest the appointment of such inferior officers as they may think proper in the president alone, no Senate confirmation, in the courts of law, or in the heads of department. And so what the Ethics in Government Act actually did was it authorized courts to appoint special prosecutors. And the idea here was that, courts are going to be even more independent than having the Attorney General appoint a special counsel. And that is what led us to Ken Starr, and so that was thought to be too much independence, so we got to the special counsel regime, which is this kind of in-between sort of New Year's resolution level of independence. And now I think that there's some view, at least Jack holds this, that even that is too much independence, that basically what should happen here is the Attorney General should stand up and say, I think there's probable cause that this person, regardless of who they are, whether it's the sitting president's son, or the former president, who's the political opponent of the sitting president, I think there's probable cause to prosecute a crime, and so I'm directing the relevant prosecutor in whatever jurisdiction, the US attorney, to prosecute those crimes. Now, I can understand why Jack thinks that now. I wonder whether he will think that next year if Donald Trump is president. Now, what happens under the system we have right now if Donald Trump is president, and he has promised to order the prosecution of various political opponents. And so the special counsel doesn't really provide that much protection in that situation because there's nothing that prevents Trump from doing that, but it'll at least be clear that he's not ordering his attorney general, whomever that may be, to appoint an independent special counsel to determine whether Joe Biden committed crimes related to Burisma in Ukraine or something like that. Instead, he's just going to say, attorney general, whoever, prosecute my political opponents. And so at least it would be clear, look, there's a way to do this the right way, which is what Merrick Garland and President Biden did. At least try to have some level of political independence for the prosecutorial decisions. And then there's the wrong way to do it, which is just prosecuting your opponents. Now, I think that's a really difficult question because right now we do have a system where, is Jack Smith accountable to the Attorney General or not? Somewhere in between. And that's not great. And what we learned from the independent counsel under the Ethics in Government Act is if you have a really, really independent counsel, then you have someone who just goes for their own purposes to look and find whatever scandals there are. And so the Whitewater investigation was about a land deal in Arkansas, and it led to an impeachment about an affair that President Clinton had with an intern in the White House. Those two things are not the same thing. But the independent counsel, who could not be fired by Attorney General Janet Reno, decided to take the investigation quite a bit further. And so there is this trade-off between independence on the one hand, which seems nice and seems like a rule of law value, versus the lack of political accountability that you have when there's a prosecutor who doesn't really have a day-to-day boss. So I don't know what the right answer to this is. What I do think is that it is another example where the former president's conduct has pressed the legal system, has stressed the legal system in ways that are unprecedented. We never really had to worry before about whether a former president was immune from federal criminal prosecution for acts taken while in office because it had never come up. Similarly, we haven't really, until the last several years, had to confront the possibility that a president might order the prosecution of his political opponents. So, I don't know that there is a good answer in those circumstances.
Thank you.
Yes, thanks.
Matt, great presentation. Thank you for that. What Judge Cannon is doing doesn't happen by chance. That is her perceived bias or her bias. Is it more endemic that, what we know in the Supreme Court, like Justice Alito or Justice Thomas, they are so biased, or there seem to be, in a sense, there's a sense of corruption over there, that the lower judges feel that they can get away with anything? Is this just the third, our branch of government has gone corrupt?
I think it's a little bit more complicated than that for a couple of reasons. First, I am not a pure legal realist, which means that I don't think that, what the judge ate for breakfast determines what they decide, or, more plausibly, what the judge's political interests or biases always decide the case. And I don't think that's true of this Supreme Court. Now, you may be surprised to hear me say that, but there are decisions where this Supreme Court has decided cases that don't actually comport with whatever the political views of its members, or at least some of its members, hold. So for example, the Voting Rights Act was attacked, and it was widely anticipated that the Voting Rights Act would be struck down as unconstitutional. And this was 2 years ago. And in a decision by Chief Justice Roberts, he upheld it. And I think it's fair to say that if he has a singular issue that he cares about more than anything else, as an ideological matter, it's that government should get out of the business of race. And nonetheless, he decided in a way that was not consistent with that. Now, this leads to another point as well, which is, well, is that something that the Chief Justice cares about for political reasons or ideological reasons? And the answer is ideological reasons. He has no political incentives whatsoever in that. It's just he's believed for decades now that it is both morally repugnant and unconstitutional for the government to engage in any kind of race-conscious action at all, even if it's remedial of prior discrimination. And so what we shouldn't do is underestimate the extent to which, on those types of cases, ideology and not politics is what drives the justices. Now, that can be cold comfort, though. For example, in the Dobbs decision, I don't think that any of the justices in the majority were motivated by political reasons. If anything, if they cared about the Republican Party's prospects, they would have gone slower. They would have waited until after the 2024 election to overturn Roe v. Wade. But they were ideologically driven. There was nothing that was as central an article of ideological faith in the conservative legal movement than that Roe was wrongly decided, because in their view it made something up. So that's point number one, which is this is ideology more than anything else, at least when you're looking at the Supreme Court highly charged cases like that. Now, the immunity decision, is that just political? A lot of people think it is. And I am, I think, viewed as naive among some of my colleagues for thinking that actually it's still ideological. I think that the Chief Justice wrote that decision because he cares about the institutional integrity of the judiciary, and his view, I think, is that the danger to the judiciary is becoming involved in a cycle of reciprocal prosecutions by administrations. And so the way to protect the judiciary is to keep it out of criminal prosecutions, ideological, not political. And now let's talk about Judge Cannon. So Judge Cannon might plausibly be a bit different. And the reason is because I don't think that there's much ideological here. She might think there is. Now, it is an article of conservative legal faith that the independent counsel was unconstitutional. So it was upheld in Morrison v. Olson 8-1 with Justice Scalia writing a dissenting opinion, which is, I think, fairly lauded. It's one of the most beautifully written opinions in Supreme Court history, in which he said that this statutory scheme where there's a prosecutor who is not within the Department of Justice, who is not accountable to the president at all by statute. Congress has said, President, you can't fire this prosecutor. That, he thought, was a grave threat to the separation of powers and to presidential power. So there is that ideological part to it, but that doesn't come up here. This is just about what that statute means. And so you might think that Judge Cannon, in the context of other decisions she's made about the case to interfere with the FBI's review of the evidence that was seized at Mar-a-Lago, this decision, some other weird procedural decisions she's made, including the decision to have me argue in that case, give rise to something more than just ideology. It looks like it can look to some people like she's trying to further the political interests, personal and political interests of the defendant here, with the idea that if he wins election, she may have a job promotion. And that is something that is a very serious concern. I also don't know what to do about it because, the concern could have been on the other foot if you had, say, a Biden-appointed judge presiding over the case, or even Obama judges or Bush judges. Now, the Chief Justice says there are no such things, but I think at least sometimes there are. So I'm not sure what the ultimate solution is, except for judges to exercise a little bit of integrity and self-restraint, not to do things that give rise to the fair inference that they're not deciding the case on the basis of the law, but rather potentially are trying to impress a future president for a promotion.
Thank you.
Yes.
I just want to say thank you for sharing your insights. Yeah, super interesting.
Can you speak up a little bit, please?
I just said thank you for sharing your insights. My question relates to your argument that there was a reasonable apprehension of bias on the part of Judge Cannon, and I understand that you wouldn't have made that argument lightly. And I was wondering if there was a turning point or a key bit of evidence where you felt like today, like this is the case where I have to do it, or yeah, that persuaded you to put that argument forward.
Sorry, what's the question? So the question for those who didn't hear it is, the questioner recognized, I hope, that I wouldn't make the argument that Judge Cannon was biased and therefore should be removed from the case lightly, which is true. And then the question was there a moment that made me sort of cross that threshold? And it was at the very last minute. So I wrote the brief not including that argument. And then some of the amici that I represent, along with some colleagues, asked me, hey, should we make this argument? Now, the primary reason why I didn't make the argument at first is because the special counsel didn't make the argument. So the special counsel filed his brief a week before ours was due, and it was sort of widely anticipated that the special counsel might make this argument, and what does it mean if the special counsel doesn't make this argument? And so I thought that it was probably better not to get out in front of the special counsel. But then I was persuaded by talking to some of my amici client that there are good reasons why the special counsel can't make this argument. The reason why the special counsel can't make this argument is because it's sort of like that line in The Wire, if you come at the king, you best not miss. And so if the special counsel makes that argument and it fails, then the special counsel has to go back to Judge Cannon and try the rest of the case in front of a judge who the special counsel has argued should be removed from the case because she's so biased. But I was not subject to that same strategic consideration. And so as a result of that, I was persuaded that we could make that argument. I also did some legal research, the best of which always comes up in a footnote. So there's a footnote in our brief that says that this issue about bias and the removal of a district judge can be addressed sua sponte by the court. It doesn't require a party to raise it. So it was because of those strategic questions, more than anything else, that I was persuaded that it actually, I wasn't getting out ahead of the special counsel, but rather I was saying something that the special counsel strategically could not say. Yes.
I'm just a layman, so what do I know? But when the Trump classified documents case landed in Judge Cannon's courtroom, it was blindingly obvious to me and a lot of other people that she will find some way to not hold him accountable. And you can look at this in isolation, but if you look at the pattern of all of his other cases, one time after another, the legal system has found some way to come up with some reason to not hold this guy accountable for anything. And so my question is, why should I as a layman have any confidence in a legal system that consistently declines to hold him accountable for anything? And how can I get that legal system for me if I ever do anything bad?
Look, I think it's a fair question. I mean, the amount of pressure that's been put on the legal system and the rule of law is pretty extreme. And so I think it's fair to have questions about the core fundamental premise of the rule of law is equality before the law. And you might fairly wonder whether that is a principle, a value that the federal courts are upholding right now with respect to this particular defendant. Now, so can I give an optimistic take? And the answer is a qualified yes. The reason why it's a qualified yes is because if we think back to 2020, and so my primary area of practice is election law, and there were opportunities for the federal courts to rule in certain ways that would have helped Donald Trump's attempt to remain in power, including by the Supreme Court, and it never did. Every single case went against the former president, with the exception of one case that affected a relatively small number of ballots in Pennsylvania. Because this is already coming up again this cycle, it's mail-in ballots that are undated but received after Election Day. Are those ballots lawful? And the Pennsylvania Supreme Court said yes. Some people say the statute says otherwise. And so there are questions like that, which are arguable legal questions. But with respect to the election itself in 2020, the legal system was the strongest part of our legal and political system. Obviously, Donald Trump was not acting in a way that you would hope when he was president, still sitting president on January 6th. There were 148 members of Congress who voted to object to the counting of indisputably lawful electoral votes. And so whatever flaws the judiciary has, and it has many, the question is, who else? And so one of the things that Judd mentioned that I'd worked on over the last couple of years is there's a new law, the Electoral Count Reform Act, which was quite shockingly to me, passed into law and it strengthens the legal architecture of how electoral votes are counted by Congress. And one of the things that it does is it makes it so when the governor certifies the state's electoral votes, federal courts can review that. And you might say, why would we want the Supreme Court of all people to be in a position to potentially throw the election by saying, oh no, that certification of Harris's electoral votes was unlawful? And the answer is because what's the alternative? The alternative is that there's a governor. Pick your least favorite governor in the United States. You want that person to have unreviewable authority to potentially certify the wrong electors? Similarly, with the criminal cases that we're talking about, who's the alternative? There isn't any, unless we're going to go back to the old way of handling prior chief executives that had engaged in alleged misconduct, which is the guillotine. So unless you're going to do that, we have to rely on the judiciary. Now, what can we do to potentially fix it? Well, I think the problems with the judiciary are probably just symptoms of a deeper disease that we have in our body politic, and so we have to try to return to a place where our greatest allegiance is to democracy and the rule of law rather than political outcomes in any given case. Now, I don't think that's there for a lot of America right now, and that's why we are seeing this. That is why we are in the political environment where we are, where we do have a situation where we have to ask in this election, is one of the candidates, if he wins, going to pardon himself from federal crimes? I think the way to solve that problem is really, we have to solve the deeper problem with the American political community before we can fix the courts. Yes?
Yeah, first of all, thank you for being here. I wanted to go back to 23 U.S.C. section 533.
Yes.
Talking about where you said that it's not dispositive, that just because that section is included in the FBI chapter of the code, that doesn't necessarily preclude Jack Smith from being incorporated into it. And you said we can go into why, and it's not clear to me why that would be. So,
sure. There's three reasons.
Okay.
The first is, okay, so if Judge Cannon was right about that, then it turns out, surprise, Jack Smith is an attorney in the FBI and could prosecute this case. So the complete upshot of that argument is that Jack Smith, it turns out, gets put in a different place in the org chart of the Department of Justice. That is the entire upshot of the argument. Reason number two is that there are numerous Supreme Court cases that say that the title of a provision or title of a chapter in which a provision is codified is relevant to the interpretation of that provision only if there's textual ambiguity. I don't think there's textual ambiguity there. And then third, and so this didn't come up in the district court briefing, and I'm kicking myself about this, but I did include it in my Court of Appeals brief. So this provision here was originally enacted as sort of an omnibus bill. And it enacted a whole bunch of different provisions all over the United States Code. And then the particular part that enacted this, there was a couple dozen provisions that changed 23 U.S.C., various parts. And in the enrolled bill, it says that the placement of the codification of any provision shall not be used to inform its meaning at all. And so That, I think, pretty clearly suggests that Congress didn't intend to suggest that by codifying Section 533 within a part of the United States Code that otherwise talks about the FBI is supposed to be limited in some way to the FBI. Now, there's a little bit of a background legal fact here that is relevant to understanding what I just said. So when Congress passes laws, it's changed over the years. It used to be that it would pass a law and it would say Section 1, Section 2, Section 3, blah, blah, blah. And then that would be codified in the United States Code. And the codification, the thing that turns it into something, something, USC, section something, something, was not done by Congress. It was done by the clerk. And so for a very, very long time, the codification literally had no legal import whatsoever. So there's something called the enrolled bill rule, which says that the codification is only evidence of what the law is. The law itself is the actual bill that was passed by Congress, which makes sense. And there are a handful of Supreme Court cases over the years where there's actually been a conflict between the enrolled bill and the codification. Now, in more recent years, what Congress often does is it passes a bill that dictates what the codification is. And so you'll have a bill that says, you know, section blah, blah, blah of the United States Code is deleted and replaced with this. And so it avoids that problem a little bit. But still, frequently, it will say that the codification is not supposed to inform what the meaning is. Thank you. Yes?
So it seemed to me that Judge Cannon's argument was kind of following in Justice Thomas's footsteps in his concurrence to Trump v. U.S. And I was wondering if you think there's additional buy-in to this argument, because Justice Thomas was alone in his concurrence, and so whether at the 11th Circuit or at the Supreme Court, if you think that there are justices who would vote for this argument.
So this is a question about Justice Thomas's concurrence in the immunity case, Trump v. United States. And in that case, the majority of the court said that there is immunity subject to complicated rules for certain actions that the president takes. Now, Justice Thomas, so I was in the room during the oral argument, and Justice Thomas asked this completely out of nowhere question, is the special counsel even constitutional? And this was an argument to Trump's lawyer, and he said, well, we haven't raised that here yet, but we've raised it in the Mar-a-Lago case. We will raise it on remand, which indeed has happened. And so then Justice Thomas wrote a concurrence raising exactly this point. And Judge Cannon cited that concurrence as authority in her decision, holding aside the fact that there were 9 Supreme Court justices who had previously held the other way. So you might think the 9 is greater than the 1. Now, the question you're asking, though, is do I think that the argument might end up winning at the Supreme Court? I think the answer is no, but I have to say I didn't think it was going to win here either. Now, I do have a bit more faith in Chief Justice Roberts and Justice Barrett than I do in Judge Cannon to interpret this statute properly. So, you know, I think I'm still optimistic. Do I think there will be 2 or 3 dissents? Yeah, I do. And the 11th Circuit, we don't know what the panel is yet. It used to be the most conservative circuit in the country. It is no longer the most conservative circuit in the country, but you can still get a panel that's, you know, pretty conservative. But arguably the most conservative member of the 11th Circuit is Bill Pryor, Judge Pryor, and he was the one who authored the Pryor decision, as they say, smacking down Judge Cannon, saying that her interference with the FBI's review of the documents in this case prior to the indictment was, violated bedrock principles of the separation of powers. And so that's, the most conservative member probably of the 11th Circuit. So I'm still optimistic, but I do think that we live in a world where, having a 9-0 decision in the Nixon Watergate tapes case, that kind of unanimity is probably beyond reach for the time being. Yes.
So first of all, thank you very much for coming to talk with us and the work that you did on behalf of the country towards this document case. I guess the part that I'm really perplexed is why hasn't it taken like 3 years plus to bring these federal cases forward? It seems like bringing them forward on an election year is just bad.
So there are 2 questions here, and they're both good ones. The first question is, why did it take so long to get to this point? And then there's a question about the timing of the case during an election year. So the first question, the Attorney General waited about a year before he appointed Jack Smith, and a lot of people think that that was a grave error. It was pretty clear on, let's say, January 7th that something had gone horribly awry. And so that at least warranted investigation. And so you might have thought that on January 21st, once he wasn't yet the Attorney General because he hadn't been confirmed, but a couple months later when he was, that would be a good time to appoint a special counsel to investigate at least the January 6th portion of this. I think the reason why the Attorney General didn't do that is because he had hoped that we would just move on. That he thought that, like the Chief Justice, and that's not a coincidence, think that it's not great to get into a world in which former heads of state are being prosecuted by future subsequent heads of state. And he's certainly right about that. That's bad. I would much prefer we not live in a world in which legally and factually justified prosecutions of former heads of state in the United States is a thing that happens. So I think that he was hoping, as an institutionalist, which Merrick Garland is, just like the Chief Justice, I think they were just hoping that things would move on. That didn't happen. And so ultimately it became unavoidable. And now it's not a coincidence, by the way, that the appointment of the special counsel happened, was instigated by the classified documents case, not by January 6th. So there had already been sort of a back and forth between the National Archives and the FBI and Trump, because other former presidents and vice presidents have unfortunately accidentally taken some documents, and so there's this process where the National Archives gets involved, and then the FBI, et cetera. And only once it had become absolutely clear that there was a crime that was committed that couldn't be ignored. These are the most secret of secret documents about war plans. I mean, today, Iran launched a missile attack. And some of the classified documents were American military responses to Iranian missile attacks. And so it just got to a point where there was no way that Donald Trump could not be prosecuted for intentionally and willfully retaining these documents. And it's really an open shut case. So I think that's what finally pushed the Attorney General to say, okay, I have to do this anyway. Then we get to the judicial system. Some of this is just the judicial system works slowly, and some of this is intentional foot dragging, like Judge Cannon did. Now, I was actually surprised that she decided this issue as quickly as she did. I thought she was just going to sit on it for 6 months, see what happens in the presidential election, and then go from there. And the Supreme Court and the immunity appeal. So there was an opportunity for it to step in December. Jack Smith had asked the Supreme Court to step in before the DC Circuit did. I thought it was blindingly obvious that the Supreme Court was going to need to weigh in on this one way or another. And let me tell you, as someone who clerked on the DC Circuit, the Supreme Court does not care what the DC Circuit says about anything. So it's not like they were going to read that opinion and be like, oh, now I understand the issue better. So they could have just taken the case in December of 2023, decided it by February, if it had followed the same timeline as, for example, the Nixon Watergate tapes case, but it didn't. And so there's been some judicial foot dragging as well. On a macro level, I think that what it reveals is that the American political system, legal system is not built to deal with these types of situations where there is no good answer about whether there should be a prosecution of Donald Trump in fall of an election year where he is a candidate for president. It's just not, there is no good answer to that question. If you intentionally withhold prosecution, then you're helping him. But if you let a prosecution go forward, there's no way that you can say that that doesn't impact the political system. As somebody who supported that prosecution, yes, I know. That's not why he should be prosecuted, but you have to recognize the fact that his prosecution would then impact political outcomes. And for many people, that was a hope. So, I think the upshot of this is just that, the existence of these cases is a symptom of a problem that has no resolution in anything like an orderly legal system. Yes?
Just a quick comment. Alito and Thomas are the oldest justices. If we had a President Harris, there's a fine chance that over the next 4 or 8 years, the 6-3 so-called supermajority could be turned into a 5-4 liberal majority. I think the Supreme Court's motivated by that.
It's possible. I personally am hoping that we see I'm sorry? Oh, the question was, the question was, it was an observation that if Vice President Harris wins, then Justices Alito and Thomas are pretty old, and there's a decent chance that a hypothetical President Harris would be able to appoint replacements for Alito and Thomas, and that would then reverse a 6-3 supermajority conservative court to a 5-4 majority liberal court. I can't say that they're not totally motivated by that, and there are personal accounts of some of the justices who participated in Bush v. Gore that indicate that some of the justices in that case were motivated by precisely that.
All right, before we thank Matthew, I'll just note that we have another event next week, next Wednesday, back at the usual time, 5 o'clock. In this room, Kurt Bradley will be talking about his new book on foreign affairs and historical gloss in interpreting the Constitution. So please sign up for that. Look forward to seeing you next week. And want to just extend my thanks and join me in extending thanks to Matthew for such a great talk. Thanks so much.
Thank you, everyone.